was in the whole county, I'm like, oh, that's good. Oh, my God. Well, I'm residing in Tampa right now. So, looking at, stuff in the areas like, and we had built, for satellite campus. And we have very close to that. Yeah, yep. Used to be late. Well, it had not. Unfortunately. Steve didn't do this. Okay. Awful.
All right. Court of Appeal and for the 6th District Court is now in session. The Honorable Dan Traver, Chief Judge, presiding. All those with the court draw near to the attention and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
All right, good morning, everybody. Welcome to an oral argument session of the 6th District Court of Appeal. I appreciate the introduction. My name is Dan Traver. I'll be presiding over today's session. We have two cases on our docket. Before I announce that, let me introduce you to our panel. Seated to my right and your left is the Honorable Jared Smith, and seated to my left and your right is the Honorable Eric Netcher. Judge Netcher, his day job is as a circuit judge in the Ninth Judicial Circuit, and he is with us through the good graces of the Florida Supreme Court's Associate Justice Program, and we're really thrilled to have him aboard. This is being streamed live on YouTube. If you haven't already silenced your cell phones, we would be truly grateful if you did. Our first case on the docket this morning is case number 24-1015, Winter Haven Hospital, Inc., doing business as Winter Haven Hospital versus Carrie Howland, Mark Howland, et al. Ms. Stein, how much time would you like for rebuttal, ma'am?
5 minutes.
Whenever you're ready.
Thank you. May it please the court, Dinah Stein on behalf of Winter Haven Hospital. And we contend today that the trial judge was absolutely correct the first time around when she dismissed the uncorroborated medical negligence claim against the hospital, and she erred as a matter of law when she, on reconsideration while it was pending on appeal, reversed herself and held, based on plaintiff's argument about a conflict, which is incorrect, that it was not subject to dismissal. We also contend that the ruling below is absolutely reviewable by this court at this time. And I will start with the jurisdictional argument because, obviously plaintiff appears to be at least taking a position that when the Supreme Court ruled in Carmody, it was limiting the ability for courts like these to review any of these types of orders of noncompliance with pre-suit. The Carmody decision, to the contrary, realized how important it was to have interlocutory review of these orders and expanded the ability to review these orders by creating an appellate rule. It said, we're not changing the rule on certiorari. We can't. It doesn't allow discretionary type rulings about the quality of pre-suit. So we're going to allow an appellate rule for these quality-based rulings on pre-suit, and all the rest, which it called process related, it said that's still subject to certiorari, just like the Oken case held, and just like the courts have held, such as in the First District, the one that certified conflict in Carmody, in Pusha.
Can we start with 9.130? And there's two components for me that I want to ask you about. First, it has to deny a motion to dismiss on the basis of qualifications of a corroborating expert witness.
Yes, Your Honor.
As I understand the trial court's order, the motion to dismiss was granted on grounds other than the qualifications. Isn't that correct?
The motion to dismiss originally, well, there was a lot of discussion about his qualification, and it held that since Dr. Shashadi was an internal medicine doctor,
putting aside the qualifications issue, because it's clear that at a minimum the trial court disagreed with your position that there had to be compliance with pre-suit for a separate provider when the entity is allegedly vicariously responsible. But putting that aside, as I understand the trial court's order, they agreed that the complaint didn't state a cause of action because of the conclusory nature of it, insufficient allegations, and so they grant the motion to dismiss. So was there ever a denial of a motion to dismiss that is on review?
Yes, Your Honor,
Okay.
because the court did not dismiss with prejudice. And that's the problem, is that we were entitled to dismissal with prejudice because of pre-suit. The other thing, and I appreciate Your Honor's your question, it's important. This is an issue of whether the hospital is entitled to interlocutory review of a non-corroboration. We can't be kept in limbo like that and never have review.
That sounds like a cert argument, and then we can get to that. But on 9.130, I'll move to the second one. What about this particular order is on the basis of the doctor's qualifications?
So yes, Your Honor. So and I'd submit that the court did not discuss his qualifications for naught. She very specifically, I think on page 2, goes through his qualifications and says, I understand he's an internal medicine doctor. I find that sufficient because there was an internal medicine doctor at the hospital. And it's our position that it had to be from a board certified, or not board certified, but a qualified radiologist. So it is essentially finding that I find Dr. Shashady qualified because there are other potentially negligent employees at the hospital. So I do believe it falls into the appellate rule. But of course, we anticipated that, you know, in case that your honors disagree, then absolutely there's the safety net of certiorari, because the court, the Carmody court, never held that there's going to be the most egregious violations of pre-suit are just not going to be subject to interlocutory review. It recognized that these, and that's why it depends in some ways how you characterize the court's ruling. If you characterize it as saying that Dr. Shashady's qualified, then it is based on his qualifications. If you characterize it as just rejecting our argument that they failed to comply with pre-suit as to this claim, then it's certiorari.
Do you know, I don't know if it's part of, of the record, but the status of the pleadings? Was there an amended complaint filed after the granting of the motion to dismiss?
I believe there is, and I apologize. I know that there is motion practice going back and forth, so I apologize for not knowing the
and
answer.
And on cert, to the extent we're getting there, it sounds like you might have some agency arguments, some non-delegable duty arguments as it relates to the issue of vicarious liability. What do we do with that? Meaning, there's gonna be a lot of chance for this issue not to even be an issue ultimately at the conclusion of the case. And you are already there litigating, meaning traditionally when we think of cert, it's in med-mal context, it's because you are being deprived of your right not to have to face this case. The hospital is already there litigating and interjected the issue of the radiologist. So how is this not remediable on appeal at the conclusion of the case?
So the courts have never distinguished it based on, you know, what if you win at the end? And it's never been either that or timing. So in other words, you know, there very well may be good defenses to the agency claim. That's never been the test on pre-suit. It's whether the defendant was received the rights it's entitled to under the statute. Period. The end. You know, if they don't make that threshold showing, they just don't get into issues like agency and force the hospital to defend itself on issues like that. Number two, there are multiple reasons for having this pre-suit. Some of them have to do with not just the corroboration, but the early opportunity to settle claims, to request arbitration, to investigate the claims during pre-suit. So it's not just corroboration that the hospital.
Posture, though, in this particular case, where your colleagues are going to assert or have asserted below that the radiologist didn't do anything wrong, or I'm sorry, that you're asserting that the radiologist did something wrong and they're not. So it seems to me that if I look at the way that this all started, going back to Williams, coming up through Carmody, we don't have an analogous sort of situation to what you're talking about.
Well, it is analogous in the sense of this, and that's plaintiffs have tried very hard to make the Fabre kind of like a mirror image of the claim. It's not. I mean, it's putting aside burdens of proof, and I think Guzman really speaks to this. A Fabre defense doesn't admit negligence, but of course it says, but if we are negligent, you know, the jury has to look at the whole picture. The Fabre defendant is not being asked to be responsible for this alleged negligence. They are not being asked to be out of pocket for the alleged negligence. It's a defense. Now, the mirror part of it, the non-mirror part of it is we're being asked now to answer for any alleged negligence of the radiologist. We're the ones who are a defendant who are going to be out of pocket because of that. And we're the ones who have the right in pre-suit to be able to investigate it, respond to it, perhaps settle it, and demand arbitration. So even though we're later in the case than Carmody, we're still denied the rights that we were entitled to at the time of pre-suit. And there's no exception to pre-suit and certiorari and appeal that says, well, look, if you've gone this long in litigation, it just doesn't matter. we could still be held liable for this claim that we were statutory allowed to investigate in pre-suit and do whatever our rights were.
Why do you suppose the second DCI on remand dismissed Jackman?
I don't know, because they never wrote an opinion. However, I think it could have been because they felt that since they called it a non-process related error, that they felt this would have fallen under the appellate rule, and we were well beyond the appellate time in that case. But there was, it's a bit mysterious. There's no answer to that.
Is one possible reason that in that case, just like in your case, and this is kind of to my colleague's point, that the case is going to trial. This isn't and if the jury returns a $0 verdict against your client, then you're happy, you don't care. And there's certainly no appeal that comes out of that from you. If we look at cert on irreparable harm, kind of on that fundamental level, as opposed to how I think you have to try to cabinet, which is issue specific. Could you address that particular concern?
Well, let's first go to Jackman, and I think we know very clearly that that was not a concern of it, because it made it clear in its opinion when it said it didn't even get to the qualification level except for one part of the opinion. It said, you haven't even corroborated this, you're out. We grant certiorari. It had absolutely no problem other than the conflict.
That was before Carmody, though. Are you talking about the original opinion?
The original opinion, which recognized the conflict. It certified conflict, but it said otherwise we find the irreparable harm. And irreparable harm was not the issue with the conflict. It was whether there could be a departure from the essential requirements of law for these discretionary type rulings. So the irreparable harm element was never an issue with the second district. And you could look at the opinion and see that they were.
Well, I mean, they dismissed it when it came back after Comfy. That's why I was.
Right. No, it was. I'm very confident answering that by saying it would have been based on whether it was just reviewable on the essential requirements of law based on the Carmody conflict, because that's the only reason they just
Wouldn't
the
you
order.
deny if you got to the merits as opposed to dismiss, though, if you got to essential requirements?
That's well, that's true.
That's where I'm asking you to dismiss, because when you talk about dismissal in remand in the wake of the Carmody decision from the Florida Supreme Court, it seemed like the second DCA was saying that we don't have jurisdiction over this cert petition.
I don't disagree with Your Honor as far as how they worded it.
Yeah.
I will.
But you think they misworded it in terms of that they had to have gotten to the essential requirements of the law?
Yes.
Okay.
Yes, and maybe there was another reason for using the word dismissal, but it just wasn't at issue in the cert petition as shown by the opinion.
On the essential requirements of law, and I guess we'll let you get to the merits at some point, but on the essential requirements of law, the Florida Supreme Court has this miscarriage of justice language. It's so what degree, we don't really have any appellate opinions. You did file your notice of supplemental authority from the third DCA on this issue about separate specialties for entity defendants like hospitals. But how clear does it have to be, and to determine that it was a violation of the essential requirements of law that results in a miscarriage of justice?
Yes, Your Honor. And I think maybe the easy answer to Your Honor's question is we have the statute. We have 766.203 subsection 2, which talks in terms of claims, not, does this support an action for medical malpractice, but claims, which then references, it goes back to 766.102 subsection 5, the qualifications. So, I mean, we could start right there from the basics, is that the statute now in its present form, by incorporating the revised 766.102, does require corroboration, period, the end, I would submit. Having said that, we now have the fourth district which has talked in terms of, and this is the Rafferty case, is something in the affidavit corroborating the claim, which obviously it's finding that Davis, its prior decision, is no longer good law. It had to have. We have the Mann decision from the Second District, which was not quashed by the Supreme Court, and of course the Jackman decision, which you can look at as reference. But I think we do have a clear violation of the law, which says claims have to be corroborated. So that's probably the easy answer for both appellate review and certiorari. But as far as the merits, and I think that's the heart of it, is that the court originally was very comfortable, or at least did it based on Jackman and the other authorities dismissing the claim. It was plaintiffs that then came back with this concept from a journal, a plaintiff's journal, that that there's this law that says, and if you think about this is really what plaintiffs are saying. They can get a nurse to corroborate nursing claims against the hospital in pre-suit. And once it gets into litigation, as long as that nurse corroborated something, they can now bring claims for neurological negligence, anesthesia, surgery, administrative. They can bring negligent credentialing claims. That's the real fundamental problem with plaintiffs' argument, is that was never what 203 and 105, and I'm abbreviating 766, were intended to do. There is a reason why the qualification statute has been made very restrictive over the years. And so to suggest that there's exception to pre-suit for institutional defendants, I think is highly problematic. And it throws a wrench into all of these pre-suits where now we have, plaintiffs can just come back. And again, they're doing this to try to get an advantage. I understand these are all excellent lawyers involved, but they're not allowed to do it. And they can't say now, we have to be responsible for a radiologist that they didn't feel we had to investigate in pre-suit, who, by the way, we had no ability to talk to during pre-suit. Yes,
you're
Your
into
Honor.
your rebuttal time. Do you want to save the rest, or do you want to?
Thank you, Your Honor. I would like to save the rest for rebuttal. Thank
Okay.
you.
Ms. Norris, good morning. Whenever you're ready, ma'am.
Good morning, Your Honors. May it please the court, my name is Kristen Norris. I'm here with Brandon Breslow of Kynes, Markman, and Fellman, and we represent the Howlands. Organize a little bit here. The court below did not misapply the pre-suit statutes when it ruled that the Howlands did not have to somehow preemptively corroborate a claim of negligence by Dr. Freed when the only parties actively alleging his negligence are the defendants. And that's just not supported by any possible interpretation of Chapter 766. It's also an order over which the court does not have jurisdiction. Did you have a question, Your Honor? Okay.
Not yet.
So I'll start as my fellow counsel did on the jurisdiction question. So yes, in Carmody, the Florida Supreme Court decided to expand Rule 9.130, but in a very specific, limited fashion to address orders denying dismissal on the basis of the qualifications of corroborating witness. And essentially, an order that may essentially or effectively do that is not enough. When we're talking about jurisdiction, we have to strictly comply with what is permitted. And all that's permitted is an order ruling on the basis of qualifications. If you look at the court's actual ruling, it's in appendix page 10. It goes through the case law in Davis, Columbia, Jackman, and it rules that the Howlands can amend their complaint without having corroborated every possible theory of negligence. So I disagree that there's any fulsome discussion of qualifications. That's not what the basis of the ruling was. And you need look no further than the briefing in which the hospital argues that the ruling was that a plaintiff suing a hospital need not separately corroborate multiple claims. So that takes us outside of the rule. So now we have certiorari jurisdiction. I don't think Carmody said you get review of all process-related claims, because I think that would be extremely broad. What Carmody said is they distinguished between the kind of case in which you've been deprived entirely of your pre-suit process. You've not had notice, you've not had an opportunity to investigate the claims.
It seems like you'd have to look back at Williams and look at that language about procedure and due process. Could you address that just in comparison to this particular case?
Right. So there's no argument that the hospital had the pre-suit procedure that is required. The Carmody talks about checking the boxes. Check the box, corroborating affidavit. Check the box, pre-suit discovery, interrogatories back and forth, open an authority for them to get access to any records they needed, the ability to conduct some pre-suit discovery. In addition, the notice here was notice of a claim on failing to diagnose and treat the punctured rectum during this specific hospitalization, and that it might include not only the corroborated doctors, but other people who are involved in that specific course
How
of
far do
treatment.
we take that? Can you respond to Ms. Stein's point relative to, could you pre-suit a nurse, have a qualified nurse,
Right.
and then discover during the course of trial, or perhaps know at the outset and just kind of sandbag and amend a year or so into the course of the litigation? What are the limits of your view as to how far that goes?
May I finish the jurisdiction?
Of
I
cour's
just want to make sure I have, and then
I
let me turn
appreciate
to
that
that.
it bleeds into it
Yes,
somewhat,
they-
because I'm trying to
they
figure out which
over-
box, meaning
Right.
they talk about checking the box, but it's a little unclear what boxes are supposed to be checked.
Correct.
So they bleed,
Correct.
but you can, if you want to address it on
Right.
the merits, you may.
So I think in this case, the due process aspect was met. And that's whether you look at Williams, whether you look at Carmody, you had the pre-suit procedure. In fact, there was no argument later that that was insufficient. And then I think in this case, what you also look at, and Judge Netcher, I'll turn to your question, is when you look at these cases, when you look at Davis and you try to reconcile it with Jackman or these other cases, at what point does your claim start to extend beyond what you actually pre-suited? I think that's where the tension in the cases is. But I don't think that's a concern here, because what was alleged was a failure to diagnose and treat, and what was investigated was a failure to diagnose and treat. It included Dr. Freed's records. Everybody had them. The onus is on both the plaintiff and the defendants to conduct a pre-suit review of all claims and defenses.
Let me ask you this. Do you concede that there's no dispute, correct, that Dr. Chachate is not in the same specialty as Dr.
Right,
Freed?
there is no
That's
dispute.
not okay.
There is no dispute of that at all.
And I take it you would not be here making the same argument if you were seeking to add Dr. Freed as a defendant. Is that fair?
I don't know that we would. I don't know the answer to that question, because I do think that the corroboration requirements apply at the beginning of the case, and that this might be something that a plaintiff could do because it's within what the notice and corroboration were of the claim of medical negligence and failing to diagnose. So I think that the plaintiff may actually be able to do this type of amendment under some of the case law that's been cited. But fortunately, we don't have to decide that, because the plaintiff has always taken the position that this is not negligence by Dr. Freed. And so the only person asserting negligence is the defense. I think the judges.
I mean, but you've
Go ahead. Go ahead, Mr.
I mean, you are suing them on a theory that Dr. Freed was negligent. So I appreciate that it was interjected by the defense initially, but that doesn't necessarily mean that you have to then assert that they are also negligent.
Well,
I understand what you're saying.
Correct.
If they are responsible, if Dr. Freed is negligent, then hospital, you are responsible. But they are not now the only parties claiming that Dr. Freed was negligent. Is that fair?
I understand your point, Your Honor, but I think ultimately what the hospital wants to do is avoid liability. And I think one of the things that we've touched on a bit here is we don't know how this case is going to play out. I think that's one of the reasons cert jurisdiction doesn't exist here. It's not a case in which the hospital would be released. It's not a case in which the hospital is actually suffering any real harm from the lack of the corroborating affidavit. They have an expert. They have determined that they think Dr. Freed was negligent. So even taking it out of the Carmody and whether you have to check all the boxes or some of the boxes or how many of the boxes, even if we take it out of there and you look at this case in a vacuum, is there a departure from the essential requirements of law when a judge rules that a plaintiff does not have to corroborate the negligence of a doctor that only the defense claims is responsible? Does a plaintiff, have to go through that process preemptively, even though the statute itself says the plaintiff is only supposed to corroborate those persons that it reasonably concludes is negligent. And then here, I think at this point, this is part of an earlier ruling that the Fabre defense was actually allowed at this late date with the understanding that the plaintiffs would be able to plead in avoidance of it.
And counsel,
Yeah.
that was actually going to be my question.
Mhm.
You kind of answered it. When the concept of sandbagging is mentioned, I suppose there is the idea that on its surface, if we look at this case and we say, wow, you've got one affidavit from a nurse, and then later you try to bring up a neurosurgeon
Right.
and his negligence or her negligence. Where does that? What kind of evils can come from that, and how much do we avoid the entire purpose of the statute and the plain language of the statute, frankly, to allow that? Your situation, I see, is quite different because you actually were not the ones that first brought up Dr. Freed. It was actually brought up by the defense, and it was brought up fairly close to the ninth hour. It wasn't, the week of trial, but it was after an extensive amount of discovery had occurred, frankly, well after the pre-suit requirements were done and after you had asked them, is there anybody else involved in this during pre-suit? So everybody had a chance to throw out the name Dr. Freed, and it wasn't until what appears to be, too late of an hour for Dr. Freed to be added himself into the litigation. So I was, as I looked at this and I saw what the trial court did, because everybody up here has been in that position of being a trial court judge, and we understand, when we have these unique situations that come before us and we try to craft what we think is a fair result based on a very unique situation in the law. I saw what you had argued, where the trial court had apparently not chosen option A to just simply say, no, we're not going to allow the hospital to add Dr. Freed as a Fabre defendant.
Right.
I'll pick option B, which is I'll allow Fabre, but I'm also going to allow them, the plaintiffs, to add Dr. Freed as well as a claim for vicarious liability, which seemed like a balanced strike to me. But my question to you is, if for some reason we did rule in the hospital's favor in this situation, do we then rule in such a way that we have to say, okay, now trial judge, you get to decide whether or not this Fabre even gets added again? And there are all sorts of issues that come up with that, but I wanted to hear from you, what would your position be on that?
Right.
Do you believe that the ruling was tied together? Tell me in the record how clear it is that the trial court's ruling was tied with the Fabre and allowing you to add Dr. Freed as a vicarious liable defendant.
So they were tied to, those rulings were tied together. And I think what this really demonstrates is all of this is remediable on final appeal and as the whole nut, right? Was that ruling proper? Was a subsequent amendment proper? How could the amendment go forward? There's going to be future rulings. And they were tied together. It was at the hearing at which the amendment was argued that trial counsel said, well, if you were going to allow that, then we have to be able to plead an avoidance because that would be their agent.
I'm sorry,
Yes.
but you've said the word avoidance now twice, and I'm wondering if that might not be the proper way that this should have gone down, meaning the affirmative defense is permitted, and then you're permitted to reply in avoidance, meaning they can argue that Dr. Freed was negligent. You can present evidence that they were an agent or that somehow the other side is responsible. If you are correct, they don't get to offset the judgment amount. If they are correct, they do get to. Not that you could get affirmative relief from the hospital on the basis of Dr. Freed's negligence. It seems like that's kind of what maybe the trial judge was attempting to fashion and perhaps could avoid the issue of what do we do with this affirmative defense. I'm not saying we can do that in this case, but you've used the word avoidance twice, and it seems like that might be the proper way to look at this.
Right. And I think that I've used the word avoidance because there is some remedy here, but unfortunately, whether that remedy that the trial court fashioned or how it played out is not the subject of the review here, because this has been set up very specifically to talk about pre-suit, because that's the only thing that would give the non-final review. And so we're stuck not reviewing that aspect of it. And in fact, nobody argued that the vicarious liability in the motion, it didn't say the vicarious liability claim was improper for not affirmatively alleging negligence or for being a claim that would subject them. The only argument other than the sufficiency of the agency allegations was this pre-suit, and I think by design. So whether or not that's the proper, and again, this is something that will get played out as
And do
they
you know
get
what
to
the
trial.
status of the pleadings are now in terms of,
I
was there
do
an
know
amended
that,
complaint?
yes, Your Honor, and let me answer that. So there was, the court granted dismissal with leave to amend to more fulsomely address the agency. There was an amendment. There was then a subsequent motion to dismiss. This is in our appendix. I did put it in the appendix so that it is in the record. I do not know where it stands other than that there was going to be, another amendment, and then I don't know if that second amended complaint
Did your
stands.
client undertake any effort, and this may be an unfair question, as I understand the briefing, everybody sort of discovered this potential negligence at the August 2023 deposition of Dr. Freed. We're under 2 years from that point. Is there any world in which the pre-suit process could have started during the course of the litigation? Or does the statute of limitations foreclose that?
Okay, 2 questions.
Yeah.
The first being, did this really just get discovered? The plaintiff had Dr. Freed's records. The defense had Dr. Freed's records. The plaintiff provided, did the full pre-suit and provided corroboration only on the 2 doctors because those were the only ones they claimed was negligent. But Dr. Freed's records were definitely part of this pre-suit
Yeah, the
investigation.
issue seemed in the deposition that he said something that wasn't in his records.
Right. It's not that he said something that wasn't in his records. It's that they didn't expect him to say that his report showed the concerning symptoms that people were looking for. And that now they think that he should have been more direct in his report, that it didn't fully alert them to what happened or that he didn't call them immediately. So they've developed this new theory about Dr. Freed, but he was part of the pre-suit records. He was part of the pre-suit investigation, and only the hospital has now determined that they think he's negligent, and they're perfectly permitted to go forward with that, but the Howlands don't intend to prove his negligence at trial. I wanted to go back to Judge Smith. You talked a little bit about the evils potentially of having to rule that, well, one corroboration might apply to many things. And I think the case law tries to address some of that by making sure any extension, any additional allegations still kind of relate to what was in the pre-suit, that you had notice of what you were supposed to be looking at, which is here. But there's also the opposite potential of saying that every single thing has to be corroborated when it's impossible at that stage in the litigation, and when the corroboration is only supposed to be about reasonable grounds of negligence. So no court at this point has gone so far as to say you have to have an expert corroboration on each possible person who treated the person. Maybe that's where we're headed, but right now, that's not what the statutes say. And there's also a danger here of saying that the plaintiff has to somehow make sure they corroborate anybody who might be later named as a Fabre defense. But I think those potential evils are best addressed by the legislature. If the legislature feels there's a gap here, that they need to more fully connect the corroboration requirement to every professional who is ever implicated, then the legislature could do that.
At a minimum, I take it there must be some pre-suit process. What if there's an individual that's at the hospital visiting someone and slips and falls at the hospital, and then is treated, sues for the premises case, and then says, well, wait a minute, I think there was also medical negligence. Now, Stuart Rehertz might take us out of that,
Right.
but would that fly?
Well, I think the problem with that hypothetical is one might not be medical negligence and one is, and so you would have to pre-suit one, but not the other. But let me take it more closer to the facts of our case. Do I contend that Mrs. Howland, having pre-suited this allegation that there was failure to diagnose and treat her punctured rectum, can 6 months into the litigation add a claim that on discharge, nurse so-and-so gave her a medicine that caused some entirely different injury? No, I think the case law does try to address that. you have to make sure that there was some notice there. Now, whether it gets you cert because you're not dismissing all the claims, I don't think it does, but there's some protection that can be afforded there. But when the claim is in line with exactly what you preceded, exactly what everybody was investigating, then I don't think there's a departure from the essential requirements of law. I don't, even if the amendment was permitted on the behalf of the plaintiff. I also think you can't get a departure from the essential requirements of law when this defense, negligence comes up as a defense. And I think there's perhaps two separate interpretations.
Let me ask you something, because I think you said earlier that you do not intend to prove at trial the negligence of Dr. Freed. Is that correct? So what if there is no cert jurisdiction and the case proceeds to trial? They present their and the jury finds that Dr. Freed is liable, let's just say 20%, and the hospital is liable for that 20%. If you are wrong on the merits that we're here on today, wouldn't the result be not a remand? Let's say, and then there's an appeal, and it goes up to here, and the appellate court disagrees with your position today that, in fact, you did have to pre-suit as it relates to Dr. Freed. Wouldn't the remand just be reduce the judgment by 20%?
I think that's potentially true, and another reason why this is all remediable at the end of the case. If there's an error here,
so you wouldn't be here saying we want that 20%. Is that what I'm hearing?
I can't imagine, like, as your hypothetical goes, I don't. If the court ultimately finds error in, permitting this
Of course, if
vicarious
it's
liability
90%,
claim,
you might be
Right.
wanting to say something different at that point.
right? Well. But I think ultimately it still comes down to, if there's a remedy here, everybody can make those arguments in the final appeal. This litigation is going to go forward against the hospital under any circumstance. And there's certainly no harm posed to the hospital by the lack of a pre-suit corroborating affidavit when, in fact, the hospital is the one going to assert that negligence. I think that I've answered most of the questions, but if there's not any others, we would respectfully request that the court treat this as a petition for certiorari and either dismiss or deny the petition.
May it please the court, and I'll pick up with that concept because whether it's 20% or 90% or 1%, that the plaintiff wants to hold the hospital responsible for that percentage. And
But I understood her to say that we're not going to be seeking to prove Dr. Freed's negligence. So meaning if there's no cert jurisdiction, it goes back and the case is tried and you're ultimately correct on the issue of, it would seem that the case doesn't need to be retried. You just take off Dr. Freed's percentage.
I would submit it's an empty statement when they're seeking to prove agency and hold us accountable for whatever, they say that, but it's in their pleading as an affirmative claim to hold him responsible.
If it was an avoidance, are we here? If it's just a reply to an affirmative defense, meaning kind of what I laid out to Ms. Norris, would that be a problem? If it's just an avoidance of the affirmative defense, meaning they couldn't seek affirmative relief for the alleged negligence.
I thought that through, and I think they have to plead it because it's agency.
Well, they would have
Agency
to
has
plead
to
it, but
be.
in response to your affirmative defense, not necessarily as an amended claim for affirmative relief.
I would take the position that they did what they had to do. Whether they did it as an avoidance, I'm not sure if we'd be here or not, because I think an avoidance means you just can't bring this affirmative defense. What they pled was that we're holding the hospital liable based on whatever your evidence shows. I want to, unless Your Honor had
No,
more
I'm sorry. Go
questions. I was just going to briefly go back to this concept of what happened at pre-suit and the alleged sandbagging. The hospital, and I'll just, again, repeat
I don't
that.
know that anybody up here has suggested that the hospital was sandbagging in this case. I think the concerns are of a potential ruling in the hospital's favor in this particular case that could lead to that sort of behavior in the future.
Or in the plaintiff's favor to be.
Certainly.
Thank you.
And I do think the facts show here at least that nobody's, that it's not creating any type of rule in that respect. Dr. Freed is not, I mean, he really isn't, and I know it's maybe not for the court today, but he's not an agent of the hospital, and so it's not like under HIPAA, they can reach out and talk to him during pre-suit. I'll put that out there. I know it's not really, made an issue in the record, but I'll say this much. It's not the hospital's obligation to take radiology records during pre-suit and decide whether they need to find out if there's a basis from testimony to support a radiology claim against them. That's the plaintiff's responsibility. So to the extent everyone had the radiology records, who does that fall on? Plaintiff could have done, more investigation of.
Counsel, I guess, if we were to find in your favor, doesn't that work a manifest injustice in this case because the trial court intended to do a dual step here of allowing you to add the fabre, but also allowing them to raise the vicarious? The trial court had to go through this analysis of whether there was going to be prejudice by allowing your amendment in the first place, and appeared to balance that prejudice by saying, I'll do it if they can then add this agency vicarious liability claim. If we give you a win, don't we have to go back to the trial court and say you get a second crack at this whole original ruling that you made? Otherwise, aren't we creating manifest injustice by breaking in half what appeared to be the trial court's balance to allow you to have your amendment in the first place?
And sure, and originally the trial court did not find that she needed to balance it in that respect. She applied the law and said, I free granting of amendments. They get that. And the law says I have to dismiss this claim. So she was fine to do that. It was only because the plaintiff convinced the court that the law required her to reinstate the claim that she did so. And there is no manifest injustice here because, again, one is just a defense that only applies if the hospital's otherwise negligent, the fabre. The other is seeking to hold the hospital liable. And on that, I don't think either side has cited to a single case out there that deals with pre-suit and reverses on plenary review. I mean, I just think we have to take these things as they come and deal with them so that they don't go forward like this. And we would submit that was the whole point of Carmody and the rule. It looks like I'm over Your Honor's time. Thank you for the time, and we would ask for reversal.
Thank you both for the clear level of preparation that went into the briefing and the oral argument today. We'll take the case under advisement. Thank you. We'll call the second case. All right, the second case on our docket this morning is case number 23-1050, SFR Services LLC versus the Florida Department of Financial Services on behalf of Avatar Property and Casualty Insurance Company. Counsel for the appellant, how much time would you like for rebuttal? Whenever you're ready, ma'am. Yes.
Medication that gives me dry mouth. Is that okay?
Yes.
This is a pretty straightforward legal issue that I think has been well settled, particularly with the recent proposed amendments to 1.442 and the committee comments to those. And
Counsel, I did have a question to you related to those committee comments. I noticed that those committee comments were, according to your appendix, submitted around the 2021 timeframe. they appear to line up directly with the arguments that you make in your initial brief. By putting them in your reply brief, you didn't give your opponent an opportunity to respond to those arguments. So how are those arguments not something that should have been put in your initial brief rather than attached to a reply brief? It struck me that this is not some new case that just came out recently. These committee notes have been around for a little while. Is there a reason why you didn't put those in your initial brief?
There's not a specific reason. In another case before the court, I had to do some detailed briefing after the fact on whether or not the proposed amendments to 627, 428. So it was something that I discovered during the course of briefing that and working with several, organizations that submitted amicus briefs. So it just simply wasn't on my radar. It was not intentional by any stretch.
Came to your attention after you had submitted your
Absolutely,
brief.
yes.
Okay.
I did not
Thank you,
have it
counsel,
on my
for that
radar.
clarification.
So I have I litigated a case in a similar procedural posture in front of the third, the Safe Point versus Jeannie Williams case. So a lot of what I was drawing on were the arguments advanced in the initial brief were the arguments advanced there. And obviously the third district agreed and they reversed.
Can I ask you about your second issue on appeal relative to your motion for fees?
Sure,
The insurance carrier is insolvent now, correct?
sure.
Right. Is your ability to recover fees a moot point in light of the fact that if it goes back, I assume you would have to substitute FIGA, and FIGA is going to say, hey, we can't be responsible for fees. So,
My friend Figa is here.
but that's what. Is there anything that the trial court can do if you're correct on your second point?
I'm not sure it's possible. Obviously, FIGA has made the decision to come in and continue to contest.
Well, I understood that it's the department that's here seeking
Correct,
to,
you're right. I'm sorry.
seeking to
The
recover the
receiver,
judgment as opposed to, because there was no substitution of FIGA below, correct?
Not until the appeal had already been. Well, so the procedural posture was the final judgment was entered after the stay imposed by the filing of the insolvency proceedings. So the final judgment was entered in the name of Avatar. We moved to vacate it. I think there was not relinquished, released, but ultimately the FIGA was allowed to substitute into the case. And then, so.
Was your motion ever ruled on, your motion for fees? You have the December 2021 order that followed the November 2021 hearing on the competing fee motions.
Okay.
And then you have the final judgment itself, but I didn't see anywhere in the record where there was a disposition of your fee motion.
I mean, I think it's implicit in where the trial court landed, which was she disagreed with our interpretation of
We usually
768.
review implicit rulings like that.
Well, I guess my point is,
I mean, I appreciate that there's an implied denial. You weren't going to be granted fees. But I suppose, is there anything inconsistent with the conclusion that, for example, you could have recovered a judgment for your pre-offer fees and costs, which then would have offset the insurance companies?
say that again?
Couldn't you have recovered a judgment for your fees pre-offer under 627 from the insurance company? I appreciate we're talking about pre-insolvency, and none of this may matter at this point, but
At the time of trial or at the time the offer was served?
from the time until the offer was made under 627, couldn't you have said, I'm the prevailing party, which is what you did, and I want a judgment for my fees and costs incurred to the date of the. It's what you're essentially asking us to remand to do now, but I don't know why the entry of a judgment for the insurance company on their fees would render that separate judgment impossible on your motion for fees below.
So I'm not, you don't understand how the judgment in favor of the receiver for Avatar would render, I'm not following the question.
Well, you have a judgment that was entered that's on review. And that judgment, as I understand it, awarded fees for the insurance company and also as I understand it, and I could be wrong, disposed of the main claim, because up until that point, there had not been a judgment of the, as it relates to the homeowner's insurance claim.
That's correct. It took yes, after the trial, the jury verdict did not result, the jury verdict in favor of my client did not result in the judgment in their favor.
Right, and because the amount of the fees was in excess of the $9,000 damages amount, judgment was entered for the defendant, which is totally what 76879 calls for.
Right, but you're missing the step where the verdict is not the judgment obtained.
Well, no, I understand that, and I'm not talking about your first issue. I understand your first
Okay.
issue. I'm just trying to figure out what's going on with your motion for fees and whether or not it's ever been ruled on.
Well, I would suggest that they did rule on it because, we advanced the proposition that, we should have fees, but, if this were to be reversed, and the correct law, with instructions to apply the correct law as to the judgment obtained, then there would be a judgment entered in favor of the insured, and then, then another motion for entitlement could be filed. I mean, that happens routinely when there's something, reversed. And
I think you gave this answer to Judge Netcher, but I just want to make sure that I understand it correctly. This is because of the insolvency as it relates to your ability to fee collect an academic exercise.
no, it's that my client is out of pocket $110,000.
Well, how is, in terms of attorney's fees, your client going to be able to recover that against FIGA?
I am not necessarily sure that they can. I'm not going,
But I mean, you're involved in a lot of these particular issues with insolvent insurers, so I can't imagine that this line of questioning is foreign. Are you mindful of any way, under any existing law, where you could recover your fees in this particular case against FIGA? I'll say that I'm not.
well,
But I'm willing to be disabused of that notion.
Well, so I understand that under the petty case, that even an order of entitlement prior to a judgment being entered, done, no fees, FIGA comes in. To whether or not this particular proceeding constitutes a continued attempt to deny coverage or avoid coverage on FIGA's part, I think could possibly be an argument advanced to the trial court, because that's essentially when.
How are they trying to do that when it's your appeal, though?
Well, but they're defending against it, and they're taking the position that the jury verdict came back in favor of my client, and they advanced the position to.
Let's say we agree with
avoid a
you.
covered claim.
Let's say we agree with you on the first issue,
Mhm.
and basically reverse for the entry of a new judgment that's consistent with the jury's original verdict.
Right.
How are you going to expand on that judgment with it being FIGA on the other side now as opposed to Avatar?
So I don't know that that's necessarily something that could happen, but what could happen is the judge could apply the correct rule as of the time the proposal for settlement was served, look at whether the judgment obtained exceeded the proposal for settlement,
Right.
and not apply the procedure in 768.79 and offset the verdict.
Yeah, my questions all presuppose that happens.
Okay. I don't know that, I don't know that there will be a judgment of fees. I simply want.
Let me ask it this way. You had answered in response to an earlier question that theoretically your client could, once there's a new judgment put into place, say
Right.
we remand and we agree with you on that first issue
Right.
in terms of the white formula, and there's a new judgment put into place. Could you in good faith file a motion for attorney's fees at that point?
The only way I could file a motion for attorney's fees in good faith is if there was, this proceeding could be seen as an attempt to deny a covered claim. Otherwise, I could not.
Do we have to, if we agree with you on the first issue, do we have to, because we can't direct the trial court to enter judgment against Avatar, and FIGA hasn't been substituted in, how is that going to work just from a procedural standpoint? We have to send it back to and direct that FIGA be substituted, or just leave it to your good graces to get that done at the trial level?
It's my understanding that FIGA was substituted.
Okay. Well, then-
I could be wrong about that, but they are in the case, in the lower case. So, and I think the judgment might have been vacated and re-entered, and yeah. So I think that they are, but I think I think the judgment needs to be reversed for the trial court to correctly apply, the white formula that as recently as 2021 in the CCM case was reiterated, and what happens from there, I don't know. I just know that the fee judgment that resulted in my client from the erroneous application of this law was almost $110,000. So for that point alone, this is not an exercise in an attempt to recover attorney's fees. I was not trial counsel. I have not filed a motion for attorney's fees in front of this court for that reason, because I think that there are factual issues that would need to be fleshed out as to whether that's appropriate. And obviously this court doesn't sit, as a fact-finding tribunal. So I hope that answers the question sufficiently.
Counsel, I had a question taking you. I know you weren't trial counsel, as you just said, but let's say you were trial counsel and you had been served with this proposal for settlement from the defendant for $15,000 with the express language in the proposal, exclusive of all taxable costs and attorney's fees. And you just mentioned your client is out a significant amount of attorney's fees.
Mm-hmm.
Let's say you accept this $15,000 proposal for settlement. Would you then go to the trial court and ask for your attorney's fees and costs in addition to the $15,000?
Yes, I think that under the confession of judgment doctrine, just depending on, once the money was paid, that's how typically.
And this was exclusive, and the proposal itself was exclusive of fees and costs. So I suspect that the insurance company would have expected that.
They would have. There's some war stories outside the record that these exclusive proposals for settlement are not always not contested. So,
You have said the 100, and so I'm sorry.
Yeah,
Sorry, go ahead.
would you mind if I followed up on that? So if you were seeing this proposal for settlement that they made to you, exclusive of all taxable costs and attorney's fees, is giving them the ability to later ask you, or for you to step in and ask for taxable costs and attorney's fees, how can you take a position here today to say they can't do the same thing? That the trial court couldn't have said that this proposal, based on what it says, $15,000 means $15,000 exclusive of fees and costs. Kind of what's good for the goose, what's good for the gander. If you're going to go in and you're going to say, I can accept this, and it's $15,000, and I get my taxable fees and costs. But if it's rejected, the taxable fees and costs are tacked onto this, and we get this amorphous final judgment that can never effectively be beat. How do you respond to that?
So just to make sure I understand the question, you're saying that because of the insolvency?
Well, your position is no. Forget the insolvency.
Okay.
That was their question. That was my question. My question is focusing on the language of your proposal for settlement and your request for this court to look at the White case, apply the White formula in your circumstance, even though we all would concede that White did not have your facts. White did not have these specific facts where we have a proposal for settlement that says exclusive of taxable costs and fees. That wasn't White. That wasn't any of the cases that you've put before us, save one federal case of a senior judge, which is absolutely not binding. But as for the binding authority that you've put, or even persuasive sister DCA courts that you've put before us,
Oh, that's right.
this isn't here. So it it would seem to me work a fundamental unfairness if you're allowed to interpret this to mean that it's $15,000 plus I can then later go to the court and ask for my taxable fees and costs. However, Judge, how I want you to look at it is I don't want you to include, excuse me, I do want you to include that $15,000 to include taxable fees and costs. That's what you're asking us to say. 15,000 includes everything. It includes the judgment obtained equals taxable fees and costs, correct?
No, what I'm saying, and I understand, just to make sure I have presented the court with several cases, the Safe Point versus Williams, on where there was an exclusive proposal for settlement. There's several cases cited in here that have those facts. But I understand that, this court's taken a position that, we're not necessarily bound by the other opinions that are out there. So, but, I'm the correct way for this to be handled is for the day, for the fees and costs and prejudgment interest as of the date of the proposal for settlement, to be calculated, an evidentiary hearing to be held. That's exactly what the third reversed for in the Williams case. And that's the judgment.
My point is, counsel, that 15,000 that you're looking at here today and you're telling us that should be under the White formula inclusive of attorney's fees and costs.
No, I'm not.
Then don't you lose? I mean, isn't that your whole argument, that the 15,000 should include the net judgment?
I misunderstood. Inclusive in the term
Yes.
used in the procedural rule.
Yes.
So the procedural rule just the procedural rule has the inclusive and exclusive language, but that's
No, I'm talking about
Okay.
procedural statute. Let's focus on the statute. Judgment obtained. Judgment obtained does or does not include fees and costs.
So I accepted the 15,000 exclusive.
No, at this point, I'm asking you in your position in this appeal. I guess I've moved on from my hypothetical because I don't feel like it's really connecting. So
Okay.
I'm just going to shift and I'm going to say your position before this court is judgment obtained equals fees and costs, correct?
Judgment obtained is the judgment obtained is the verdict plus any attorney's fees and costs and prejudgment interest.
Correct.
And for purposes of comparing a proposal for settlement to determine whether it triggers fees is to compare what the judgment obtained would have been on the date.
And I guess that's my point, counsel. And I appreciate, I feel like we've connected now.
Okay.
So that's your position.
Yeah.
That's what judgment obtained means,
Correct.
regardless of the fact that it says exclusive of taxable fees and costs.
Right.
And yet, if you would have accepted this proposal for settlement,
Right.
you would have stood in front of the same judge and said, I want my taxable fees and costs in addition to the $15,000. Doesn't that create an inequitable goose versus gander sort of a situation here? You're
Why?
getting to look at this to exclude fees and costs if you want to accept it, but it includes fees and costs if you reject it. Where does that fall within the bounds of equity and reading both the
Well-
statute, the case law, and these proposals?
Because the trigger for fees and costs hadn't been accepted would have been based on the confession of judgment doctrine. So, the money paid after the lawsuit being filed, that would trigger entitlement to fees. So it's a separate analysis. It's a completely separate, and that's why I started with the fact that the procedural rule, the only exception permitted other than the resolution of the entire claim is you can choose to resolve the attorney's fees or you can.
Okay,
It's not.
well, so would you concede to me that when you look at the White versus Steak and Ale case,
Uh-huh.
the whole case teeters on the fact that the court looks at this undefined term of what is net final judgment? What's the net judgment?
Right.
The court said that's undefined, and therefore we can't find that these prior cases were clearly erroneous, even though you've got two dissenters in the White versus Steak and Ale case that clearly say, look, if you look at the plain language of the statute, final judgment means final judgment. It means the full judgment amount. It means pre-judgment interest, post-judgment interest, everything that's going to be in the judgment. Judgment equals judgment. And the only way that the Supreme Court, the majority, got to an interpretation that is what we're talking about today is because they looked at a term that was technically undefined and therefore ambiguous enough that they could tack into it this idea that we cut off judgment interest and we make this line in the sand that the legislature has not clearly made within the language of the statute. But the Supreme Court conceded that on both the majority and the dissent side.
In the statute you're referring to, 768.79.
Right. And
So
so
the-
my point is, counsel, if they could do that,
Mhm.
if they could say, that there's this amorphous, ambiguous term in there that says prejudgment, net final judgment, does not include post-judgment interest, only includes prejudgment interest and costs up to the point of the proposal for settlement. Why couldn't we then take the next step and say, well, you know what? It's the same ambiguous term is there. The court didn't have these specific facts in front of them where they had a proposal for settlement that said exclusive of all taxable fees and costs. So why can't we just take the next step and say, well, hey, we've got this ambiguous term. Let's go ahead and shoehorn this in there as well. We're the 6th DCA. We're not bound by precedent. The Supreme Court isn't maybe clearly telling us one way or the other. Why couldn't we do that?
Because 627428 mandates that, and whether it's an actual final judgment or a compassionate judgment, it says that the fees and costs shall be included in the final judgment at subsection 3. So maybe this is a unique fact. This was a consumer protection statute that was in effect for over 100 years, but that's the distinction that I would argue. I mean, it's in the statute, it's plain, it should be in there that it shall.
And that, counsel, I know you're over your time, and that's entirely my fault. My colleagues are all looking at me, so.
No, not at all. All right, thank you.
Thank you.
Forgot it was there.
Please support. My name is Leila McDonald. I'm here on behalf of the appellate.
Yes, sir.
From what I heard, I believe that the court is trying to get to the bottom line of what a judgment obtained is. And by law, we know it's only the amount that can be done at the time of the service of a proposal for settlement. The jury came back with a $20,000 award to the appellant, and the court reduced.
Counsel, since I was on fire with my questioning of the last attorney, I'm going to go ahead and jump right in and ask the question that I would like you to respond to, which is the same I'd asked your previous counsel that was up here.
Sure.
So the way I read White versus Steak and Ale, as I had just said, and I'll repeat it slightly, I think it all teeters on this whole idea that net judgment is not defined, and so therefore the court felt in the Supreme Court in the CCM case felt that they could look backward to White versus Steak and Ale and say, well, because we can't find that it's clearly erroneous because we have this ambiguous term in the statute, therefore we're going to uphold the White formula, which if we follow the White formula, I think you lose. But if we say, well, hey, if they found it ambiguous, and this is my question to you, why should we not say, well, just as the Supreme Court found that provision ambiguous and was not faced with the kind of facts we're looking at here, 6 DCA, let's go ahead and continue with this whole ambiguous line on this net judgment and say that in a case where you've got a proposal for settlement that has the phrase exclusive of all taxable fees and costs, that net judgment now means exclusive of all taxable fees and costs. If you put that word in your proposal for settlement, that's how we're going to define it. Why should we or should we not do that here?
The proposal for settlement was very clear. It does not include attorney's fees, does not include taxable costs.
Doesn't that put you
15,000.
in White? And I'm sorry to interrupt this line, but my understanding of White, at least from the concurrence and the dissent in part by Justice Harding, was it was exclusive of costs. And you can quibble a lot with the reading that they gave it, but they did give it a reading. I don't know how we get around that reading in this case. So wasn't White exclusive of costs?
It was, Your Honor. In
Okay.
fact, Justice Harding said, quote, "In order to determine whether the term judgment obtained in section 768.79 includes costs, one must first determine whether the offer of judgment includes costs," and compares it apples to apples, not apples to oranges.
Right, but that's not the opinion of the court, and that's,
That's just Judge Harding.
yeah, so how, in what world do you get around White?
Here we have an unambiguous proposal for settlement that excludes fees and costs for $15,000. After the reduction from the jury verdict, reducing it from 20,000 to 9,000, our proposal for settlement then kicks in because it was rejected.
That's not getting around. Well, getting around White would mean you somehow, let me ask you this. Do you concede that the pre-offer, that the SFR's pre-offer cost and fees exceed the threshold $11,250 amount? Meaning if they were in fact included, then no fees for the carrier?
At the time that there was an evidentiary hearing, Your Honor, there was a plaintiff was seeking $23,145 in attorney's fees. At that point in time, there was no statutory basis or a contractual basis for attorney's fees.
It seems though
When it
that
was-
we don't even need to be talking about fees. I mean, I think my colleague's question is, if White applies, are they over the threshold based just on prejudgment interest and costs? You don't even get to fees. So you take the 9 and then you add the, I don't have the exact.
2,300 or so.
Thank you.
And at that
Math
point-
never being a strong suit up here. That gets you over the threshold, does it not?
If the answer to your question, Your Honor, would be yes. It would. If the prejudgment interest were tacked on, then we would.
And the reason I ask, and because I did see that from the evidentiary hearing, but I'm not quite sure. There's no transcript from the evidentiary hearing, so I don't really know what everyone thought they were doing at the evidentiary hearing. And so I don't know if you would have been in a position to challenge that. And that's why I'm asking you now, are you challenging in any respect what was presented as and offered at as the pre-offer attorney's fees and costs for the plaintiff?
Your Honor, that is beyond my knowledge.
Okay.
I was not trial counsel. I can only go based on the record that's being presented before this court.
Any reason to dispute the veracity of the supporting affidavits on those counts?
Only what the trial judge determined. And I just wasn't there. I'm so sorry.
That's okay.
But, as far as I understand from the record, the court entered its orders reducing it by $11,000 based on the Hurricane Irma deductible and other offsets that were by statute. So in my opinion, Your Honor, that the trial court did not err.
Let's say that White applies and that the trial court did err in that capacity, and that I can't get past the apples to apples, adopt the dissent as the majority argument. In that particular situation, is there any way that SFR could collect attorney's fees against the Department of Financial Services or FIGA?
The collectability is going to be a whole different animal, Your Honor. Even if this court were to reverse and remand to the trial court, at the end of the day, I'm not sure that the appellant could collect anything with FIGA.
Well, even collect, I mean, the statute, as I understand it, says that 627 does not apply to FIGA with the limited exception.
Correct.
So it's not like, in your view, could there be a judgment against FIGA? No. Okay.
No, Your Honor.
So what is your position? Because the brief didn't address the second position. Do you have a position on the second issue raised, meaning what we should do about the SFR's original fee request? Let's assuming White applies, the judgment in favor of the insurance company has to be reversed. What then, as it relates to the SFR's motion?
Your Honor, like I said, again, this proposal for settlement was exclusive of taxable costs.
Yeah, but we're past that.
Okay. I'm just making sure.
For this question,
For this particular question, Your Honor, if they were determined prevailing party, the $20,000 after the offset of 11,000 to 9,000 on the judgment obtained. If the court were to tax on prejudgment interest at the moment that it was served, then if it goes over the threshold, then obviously we would not be, we couldn't really have a position on whether they were entitled or not. I don't know what the trial court,
Do you
during the
think trial
evidentiary
court-
hearing.
Do you think the trial court ruled at any point on their motion for fees?
Well, Your Honor, when I'm looking at the order on defendant's motion for judgment in accordance with a prior motion for directed verdict, and I'm looking at the order on defendant's amended motion for remitter, and I'm looking at what the court has done, the answer would be, as I agree with appellant counsel, implicitly denied. Sorry about being too long-winded on
No,
that.
that's fair.
To address the court, Your Honor, Smith, you had made a comment about the goose be gander. And I agree with you, Your Honor, on that. It shows an unfair balance and not inequity at all. And I agree with you.
I guess my my struggle, if we were to go a route such as that, or we to take this ambiguous term and all of a sudden factor into it a new test and strategy coming out of the 6 DCA, does it really properly come out of the 6 DCA? Or is it the Florida Supreme Court that if they previously had looked at this ambiguous term, previously upheld the white formula, if they were to be presented with a situation like yours, which could have, frankly, some confusing, at the very least, results, as I tried to point out with my questions to counsel for SFR, where you're including taxable fees and costs if it's accepted, but then, excluding the taxable fees and costs if accepted, and saying you get it in addition to, and yet if it's rejected, then the trial court's expected to just look at the whole number altogether, included within the 15,000, which seems a little confusing, frankly. But is that something better set by the Florida Supreme Court, and letting them make that sort of decision? And are we, as the DCA, should we be considered bound by the express language of the White versus Steak and Ale and the CCM cases? That's my struggle. I'll be frank with you.
Your Honors, I don't want you guys to get reversed from the Florida Supreme Court. That's a fair enough. I want this court to have all the facts and information that's necessary and to do what it needs to do to, uphold stare decisis, uphold the rule of law. This is an unusual case. I couldn't find anything on all fours.
Well, when was CCM decided? What year?
CCM was 2022.
So it's not eons ago, right?
That's true, but this case was actually, the final judgment was obtained in 2021.
So
it postdates with the trial court.
The quotation from CCM is because this court's precedent is not clearly erroneous, which is when the Supreme Court is the test that the Supreme Court is implemented to decide when it's going to recede from its prior opinions. We declined to recede from the White formula. Like, how are you not done? Like, I understand that you could make an argument theoretically that we were wrong in this particular case, which would be your right if you wanted to appeal it up and had the ability to do so. But how does White in combination with CCM not doom you on the first issue? You've already told Judge Netcher that both cases involved PFSs that were exclusive of fees and costs. I just don't understand your first argument.
Okay, thank you, Your Honor, for the opportunity to clarify. We're dealing with going back in time before that decision was rendered. So we're looking at the 2021 when that judgment was obtained. That's the year, that's the date. So the trial court wasn't aware of something that happens after the fact.
You still have White approximately 20 years.
That's
earlier.
true. White,
Yeah.
White plays.
And you
To
don't,
an ex-
and
certain
I
extent.
haven't understood you to make, and you could be on some fairly solid ground in my, for what it's worth from my perspective, that White was wrong. Obviously, we can't do anything about that, but to the extent you wanted to preserve it, you could have made that clear, which I think might have been what Judge Traver was indicating. But you're not here seeking to preserve any issues for the Florida Supreme Court, correct?
I am bound to not make any disparaging comments about the judiciary. And the Florida Supreme Court is the Florida Supreme Court. If the court decides that it wants to proceed from its decision in White, then it will, at one point or another.
But I guess what I'm asking is, they're not going to do it unless somebody raises it, and you haven't raised that argument here, obviously appreciating that we couldn't do anything about it, but you haven't even made that. As I understand your position, it's this apples to apples thing, which I understand and completely from a fairness perspective, but it just seems that the ships might have sailed on that.
Again, we're looking at what the jury decided, what the trial court did pursuant to statute, which was proper. The fact that it's exclusive of attorney's fees and taxable costs is clear. If we go with White and its ambiguity argument, then I think that's where we have that disconnect. And I agree with you, Honors. I mean, if I had to preserve that on appeal, well, that should have been done at the lower tribunal. That's I can only go based on the record.
Anything else, counsel?
Thank you, Your Honors. May I be excused?
Yes. All right. Thank you both. We'll be in recess. You vastly exhausted your time.